There hasn't in reality been a lot of change to the regulatory environment that engineers operate over the past 21 years, which is somewhat surprising when you consider the increasing globalisation of the engineering profession. And we certainly feel a profound responsibility to make sure that we're setting these standards that really can define an engineer not just operating in Australia but anywhere around the globe. We're increasingly seeing a fragmentation of that system in Australia, whereby some states are developing, particularly Queensland would be one example, their own state-based registration system to define those standards for engineering practice. And whilst we think that's a good model and a good system, the very fact that other states haven't developed something that's similar or consistent with that is somewhat problematic. And when you stop and think about it and think about that very state-based orientation of some of those frameworks, then that's fundamentally at odds with this increasing national and international orientation that we see the engineering profession increasingly moving towards.
The current system is not working well because the legal profession is a services industry. And what that means is you're as good as your last job. And if you can't deliver that job because you're running around trying to catch up with regulation, then you miss out on that job. If your competitors don't have that regulation, they're into the market before you are. The problem with missing out one job is that you then miss out the second job, the third job and the fourth job, and then the current expertise declines. And that's the real threat in terms of the legal profession. We have to keep up. We have no option. We develop niches, but we do that because we do repeated complex work requiring a huge amount of intellectual capital. But there are others who can do that. So we really need to remove the fetters that stop us from competing. And that's what I see the major challenge is right now.
Regulation of the accounting profession in Australia comes from a range of different sources, and perhaps that's one of our challenges as a profession. We as the professional body regulate our members through a variety of different means: quality review, disciplinary action. Certainly the Australian Securities Investment Commission regulate our members, particularly those operating in the corporate community and in the audit profession. We would see the tax office to be regulators, particularly of our members delivering taxation services, and so forth and so forth. So it's important that for a country which is still of a modest size, that there is very much integration of regulation across the many different sources, and it's done to ensure that there is the right outcomes both in maintaining regulatory risk and maximum outputs. Regulation can always be improved. I don't feel it comes from more legislation. In fact, the real heart of how regulation can be improved means better communication and better focus between those being regulated and those with the regulatory powers as they're already established. And what does that mean? In simple terms, regulators need to ensure, including ourselves, that their ability to persuade and ensure that those being regulated understand the regulatory outcomes that are being sought is incredibly important. Otherwise, what you will find is that there's fragmentation, misunderstanding, and those outcomes that are being sought for the right reasons are not achieved because there is not a clear understanding of what is endeavoured to be delivered.